हेलो एवरीवन एंड वेलकम बैक टू योर चैनल लॉपीडिया। सो आज के हम अपनी इस वीडियो में समझेंगे आर्टिकल 226 विच डील्स विद द रिट जुरिसडिक्शन ऑफ द हाई कोर्ट एंड इसी के साथ का आर्टिकल है 32 जो कि डील करता है रिट जुरिसडिक्शन ऑफ सुप्रीम कोर्ट, जो कि हम इसके नेक्स्ट वीडियो में देखेंगे अलोंग विद द डिफरेंस बिटवीन बोथ ऑफ देम। सो आज के हम अपने इस वीडियो पे फोकस करेंगे हाई कोर्ट की रिट जुरिसडिक्शन की एम्बिट क्या है, उसका स्कोप क्या है, कौन से रिट्स हैं जो हाई कोर्ट एंड सुप्रीम कोर्ट इशू कर सकते हैं फॉर द प्रोटेक्शन ऑफ राइट्स ऑफ सिटीजंस। सो लेट्स गेट स्टार्टेड। सो सबसे पहले हमें समझना है व्हाट इज अ रिट जुरिसडिक्शन। सो the writ jurisdiction of High Court has been defined or has been stated under Article 226 of the Indian Constitution. So अगर आप Article 226 का Clause 1 पढ़ेंगे, उसमें you will understand that the High Court is empowered to issue directions, orders or writs, including writs of the nature of habeas corpus, mandamus, prohibition, quo warranto एंड certiorari. So ब्रॉडली अगर आप क्लॉज 1 पढ़ेंगे आपको समझ आएगा कि हाई कोर्ट की रिट जुरिसडिक्शन को एक बहुत ही वाइड स्कोप दिया गया है। दैट मीन्स under Article 226, the High Court is empowered to issue not only writs but directions and orders as well for the enforcement of any rights conferred by Part 3, जो कि आपका fundamental right, and for any other purpose. So जब हम आर्टिकल 32 पढ़ेंगे हम इसका डिफरेंस भी देखेंगे कि व्हाट इज द डिफरेंस बिटवीन आर्टिकल 226 एंड 32। हाउएवर यहाँ पे आपको ये समझना है कि हाई कोर्ट को आर्टिकल 226 में दो तरह की प्रोटेक्शन कॉन्फर करने की राइट है। फर्स्ट इज द प्रोटेक्शन टू द फंडामेंटल राइट stated in the part 3 of the Indian Constitution, and second is for any other purpose. So I hope you understood what is the writ jurisdiction of High Court under your Article 226 Clause 1. So अगर आप पढ़ेंगे you will understand that these writs are the greatest safeguards provided in the Constitution to uphold rights. हमारे pre-constitutional era में only the High Court of Calcutta, Madras and Bombay enjoyed the jurisdiction to issue writs. However, this particular scenario has changed. And now High Court are empowered to issue writs for the enforcement of fundamental rights as well as for any other purpose. So let's see next important factor when you're talking about writ jurisdiction of High Court. So the next important question जो यहाँ पे arise होता है is what is a territorial jurisdiction and what is the scope and ambit High Court किस extent तक आपके writs order या direction issue कर सकता है. So if you read the writ jurisdiction of High Court you'll understand that the power conferred to High Court to safeguard the constitutional rights is limited. That means High Court can issue writs to a person or authority having location or residence within the court's territorial jurisdiction, or if the cause of action wholly or partly arises within High Court's territorial jurisdiction. So हाई कोर्ट्स को एक टेरिटोरियल लिमिट दी गई है जहां तक वो अपनी ये रिट की राइट को एक्सरसाइज कर सकते हैं। सो आप पूछ सकते हैं व्हाट इज कॉज ऑफ एक्शन। कॉज ऑफ एक्शन बेसिकली होता है कि कोई भी इवेंट का जो बेसिक कॉज है वेदर इट्स होली और पार्टली इन द टेरिटरी एंड इफ इट इज देन ओनली द हाई कोर्ट विल बी एम्पावर्ड टू इशू द रिट्स। So I hope आपको territorial jurisdiction absolutely clear है when we are talking about Article 226. एक और बहुत important factor है when we are considering this particular concept is that the jurisdiction of High Court under Article 226 of the Constitution, which is essentially an inquiry jurisdiction, should not be exercised in favor of a person who approaches the court after long lapse of time. अगर एक बहुत ज़्यादा period of time pass हो चुका है and there is no sufficient explanation from the side of the person for the delay, in that case the powers given to High Court under Article 226 cannot be exercised. So now let's quickly come to the next important factor which is the writ jurisdiction is supervisory. So यहाँ पे मैंने बहुत broadly explain किया है what you can understand when I'm saying supervisory. That means the writ jurisdiction conferred on the High Court is only supervisory. It is not similar to the appellate power given. That means High Court cannot go into the correctness or merits of the decisions taken. इसका मतलब क्या है कि हाई कोर्ट सिर्फ एक सुपरवाइजरी अथॉरिटी की तरह एक्ट करता है जब वो आर्टिकल 226 में फंक्शन करता है. इट कैन नॉट रीएप्रिशिएट द इंटायर एविडेंस इन अ प्रोसीडिंग. दैट मीन्स हाई कोर्ट सारे एविडेंस को दोबारा नहीं कंसिडर करेगा व्हेन वी आर टॉकिंग अबाउट रिट jurisdiction. It's just a supervisory provision. And a mere wrong decision without anything more is not enough to attract jurisdiction of high courts under Article 226. And इस jurisdiction से courts ये देखते हैं कि that did the authority arrive at the decision according to the law. So basically what they observe is that, or what they want to ensure is that the authority arrives at the decision according to law. That means एक supervisory jurisdiction है, सिर्फ ये रिव्यू करेगी कि the manner in which the decision is made is according to the law, is according to the principles of natural justice, and वहाँ पे कोई violation नहीं हुआ है. And High Court is further not justified in expressing its views and thereafter remitting the matter. So ये particular powers नहीं हैं under Article 226 when we are talking about the writ jurisdiction. It's only a supervisory power that has been given to the high courts to uphold the rights of individuals. So I hope आपको ये particular factor भी clear है under your Article 226. नेक्स्ट इंपॉर्टेंट फैक्टर जो आप बहुत जगह पढ़ सकते हैं इफ यू आर रीडिंग आर्टिकल 226 इज अबाउट ऑल्टरनेटिव लीगल रेमेडी. नाउ अगर एक एक्ट है या एक आपका प्रोविजन है विच इज वेरी मच सेल्फ सफिशिएंट, जिसमें अपने पीनल प्रोविजंस है एंड अपने प्रोविजंस हैं जहां पे आप रेमेडी सीख कर सकते हैं, is a person authorized in that case to still go to the high court under article 226? वहां पे क्या प्रोविजंस होंगे कि जब हमारे पास एक ऑल्टरनेटिव लीगल रेमेडी ऑलरेडी अवेलेबल है, स्टिल आप सीधा हाई कोर्ट के पास जाएंगे अंडर 226 और नॉट? So now, when you'll read the case laws and the various judicial decisions, you'll understand that the High Court does not ordinarily issue writs when an alternative remedy is available. That means High Court सीधा writ issue नहीं करेंगे if an alternative legal remedy is available and it is a very valid remedy. However, it's not like a mandatory rule as सुप्रीम कोर्ट ने itself कहा है कि mere existence of an alternative remedy does not create a bar on high court's writ jurisdiction. सिर्फ इस बात से कि आपके पास एक ऑल्टरनेटिव रेमेडी अवेलेबल है एक अलग एक्ट में, ये बार नहीं क्रिएट करेगा हाई कोर्ट की रिट जुरिस्डिक्शन के लिए. उस पर्टिकुलर लीगल रेमेडी के क्या रेपरकशंस हैं, क्या नेचर है, क्या स्कोप है, ये भी कोर्ट चेक करता है व्हेन इट इज कंसिडरिंग वेदर टू मेंटेन अ पिटिशन और नॉट. If there is a labor dispute, the person should very well seek redressal or seek remedy in the Industrial Disputes Act first. In case of an income tax assessee, अगर कोई person है और the income tax assessee is not satisfied with the assessment of the income tax for a particular assessment year, he or she should very much first approach the remedies available under the Income Tax Act. Similarly, in case of arbitration clause in a contract, अगर आपके contract में एक arbitration clause available है, you must first exhaust that particular remedy available and then seek remedy under Article 226 from the High Court. This is a case also in which a petitioner challenged that the municipal tax calculated was arbitrary or vague by the Delhi Municipal Corporation, and इसको उसने challenge किया था, and this was challenged under Article 226. However, High Court rejected the petition on the ground that Delhi Municipal Corporation Act is a complete code and provides for effective remedy as well. So I hope आपको example से ये particular point clear है कि if an alternative valid legal remedy is available, the court generally wants to assure that the person is seeking that remedy before it's coming to the high court under Article 226. However, as specified earlier, it's not a hard and fast rule. Next, proceedings under Article 226 are not substitute for statutory appeal. So this is an important valid line that actually sums up जो भी हम बात कर रहे हैं, जो आपके अपील के provisions हैं, इसका substitute नहीं है Article 226. So the next important thing that we need to discuss is question of fact. Now, whenever we are talking about a case, there are two particular things, question of fact and question of law. नाउ अनदर इम्पॉर्टेंट क्वेश्चन हम यहाँ पे पूछ सकते हैं कि कौन से केसेस में हाई कोर्ट एक पिटिशन को एंटरटेन करेगा, इन विच केस हाई कोर्ट विल एक्सेप्ट अ रिट पिटिशन, वेदर a question of fact should be there or a question of law should be there, or there should be a mixed question of fact and law. Means facts के basis पे problem होनी चाहिए या law के basis पे problem होनी चाहिए या दोनों के basis पे problem होनी चाहिए, then court will see. Now the general rule is question of facts are best decided in civil suits. So जब हम fact की बात करेंगे, fact already discuss हो चुके हैं and it's best to decide. अगर आप facts के basis पे जाएंगे, it's best to go in civil suit. However, still it's a matter of high court's discretion. जहाँ पे question of fact arise होता है, high court straight away refuse नहीं करेगा. High court is very much in power if it considers the writ petition as maintainable, even if it contains only a question of fact. And in case of mixed question of law and fact, तो high court consider कर ही सकता है. And as we discussed, the High Court cannot dismiss a petition only on the ground that some disputed questions of the fact were involved. So High Court basically overall scenario देखेगा, what is the question of fact involved and whether petition should be considered on merits or not. Next, we are moving on to a very important slide, which is what are the various writs that can be issued both by the High Court and Supreme Court. So अब अगर आप broadly पढ़ेंगे, the various writs that can be issued are 5 and I'm covering in this particular slide. I'll briefly mention them again जब I'll be covering Article 32. So Supreme Court under Article 32 and High Court under Article 226 can issue 5 writs that are writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto. Let's move forward and understand what's the first writ. So the first writ is the writ of habeas corpus. So basically ये क्या कहता है? It's a Latin term which literally means to have the body of. And ये writ basically focus करता है to secure the release of a person from unlawful detention. And this writ is responsible for upholding the fundamental right of freedom of a person. इस रिट में बेसिकली ऑर्डर इशू होता है बाय द कोर्ट टू अ पर्सन हु हैज डिटेन्ड अनदर पर्सन टू प्रोड्यूस द बॉडी ऑफ द लेटर बिफोर द कोर्ट एंड कोर्ट फिर एग्जामिन करेंगे द कॉज एंड लीगैलिटी ऑफ द डिटेंशन. अगर cause and the legality of detention are illegal, the court will order release of the person. And writ of habeas corpus can be issued both against the public authorities as well as the private individuals. However, ये particular writ कौन से circumstances में नहीं issue होगा? If the detention is lawful and the proceedings is for the contempt of legislature or court, the detention is by contempt of court, or the detention is outside the jurisdiction of court. Next important writ will be a mandamus. Mandamus, it is a command जो कि issue होता है by court to public official asking them to perform their duty, जो कि वो fail कर रहे हैं perform करने में. बेसिकली ये पब्लिक अथॉरिटीज के लिए इशू होता है, पब्लिक ऑफिसर्स के लिए इशू होता है टू कमांड देम टू परफॉर्म देयर स्टेटेड ड्यूटीज. And it can be issued against public body, corporations, inferior court, tribunal or government for the purpose. And it cannot be issued against a private individual to enforce departmental instructions. And जब ये ड्यूटी डिस्क्रिशनरी है तब आप नहीं इशू कर सकते मैंडेमस, बिकॉज ड्यूटी ही डिस्क्रिशनरी है. हाउ कैन यू से कि आप मैंडेटरी है आप इसको परफॉर्म कीजिए जब ड्यूटी ही डिस्क्रिशनरी है. एंड नेक्स्ट, कॉन्ट्रैक्चुअल ऑब्लिगेशंस को इन्फोर्स करने के लिए भी आप मैंडेमस नहीं इशू कर सकते हैं. एंड इट इज ऑल्सो नॉट इशूड अगेंस्ट द प्रेसिडेंट ऑफ इंडिया और द स्टेट गवर्नर्स. Further, it's not issued against Chief Justice of High Courts acting in judicial capacity. So the next important writ is writ of prohibition. So writ of prohibition and certiorari की जब हम बात करेंगे ये आपस में related हैं. How? When we are talking about prohibition, it literally means to forbid. ये issue होता है by higher courts to the lower courts or tribunal to prevent the later from exceeding its jurisdiction. जब भी हाई कोर्ट्स को लगेगा कि दी सबऑर्डिनेट कोर्ट आर एक्सीडिंग देयर जुरिस्डिक्शन, ये प्रोहिबिशन का रिट इशू कर सकती हैं। दस, जहां की मैंडेमस डायरेक्ट करता था एक्टिविटी, प्रोहिबिशन डायरेक्ट करता है इनएक्टिविटी। And the writ of prohibition can be issued only against judicial and quasi-judicial authorities. That means ये writ आपको administrative authorities, legislative bodies and private individuals के against नहीं available है. So I hope आपको prohibition का ground और prohibition writ समझ आ गया है कि whenever the subordinate court is exceeding its jurisdiction, high court can issue writ of prohibition. However, writ of prohibition is not क्यूरेटिव। सो जब हम क्यूरेटिव की बात करेंगे, रिमेंबर वी आर टॉकिंग अबाउट certiorari. So what does this mean? In literal sense it means to be certified. So ये particular writ issue होता है by the higher courts to a lower court or tribunal, either उनको ये डायरेक्ट करते हुए कि ट्रांसफर कर दीजिए the case pending with you to itself or to quash the orders of the later in a case. And certiorari issue होता है in cases of excess of jurisdiction or lack of jurisdiction or error of law. Mind you, grounds आपको दोनों के थोड़े से similar लगेंगे, both certiorari and prohibition. However, दोनों के motives अलग हो जाते हैं. Thus, unlike prohibition, which is only preventive, certiorari is both preventive as well as curative. And like prohibition, it is also not available against legislative bodies and private individuals. Now the last writ जो हम देखेंगे यहाँ पे, it will be a quo warranto. So now in literal sense, quo warranto basically means by what authority. So ये particular writ issue होता है by the courts to inquire into the legality of claim of a person to a public office. So ये कोर्ट ये रिट तब इशू करेगी जब उसे एक पब्लिक ऑफिस के अपॉइंटमेंट की लीगैलिटी को चेक करना होगा. Hence, this writ can be issued only in case of substantive public office of permanent character created by a statute or by the constitution. So जब हम पूछ रहे हैं by what authority are you there in that particular position, so we can question only a public office or a public authority जो कि एक statute ने create की है या वो created है by constitution. And it cannot be issued in cases of ministerial office or private office. So I hope आपको quo warranto भी clear है. Just remember this particular question mark. It deals with by what authority. So this sums up our video for today. And we come to our last slide, that is revise, repeat and remember. So आज हमने comprehensively discuss किया है Article 226. We dealt with what is Article 226. We understood what is Article 226 important clause 1. Then we understood the jurisdiction factor. What is the territorial jurisdiction of High Court? जब भी हम बात करेंगे Article 226 की, कहाँ तक High Court writs issue कर सकता है. Next we discuss the alternative remedy कि अगर एक सिनेरियो में alternative remedy available है तो उस केस में क्या आप सीधा High Court को अप्रोच कर सकते हैं under Article 226 or not. Then the last important factor in this particular video we discussed was the various writs and कौन सी bodies के against आप writs issue कर सकते हैं, private bodies, state bodies, and what are the 5 important writs present in our Indian Constitution which can be issued by the Supreme Court under Article 32 and High Court जो कि हमने आज discuss किया है in Article 226. So thank you so much for watching today's video. Please do click the subscribe button so that you're notified whenever I'm uploading a new video. Do remember the next video will be on Article 32. Stay tuned and do click the subscribe button. Until then, stay home, stay safe and keep learning.